And greetings and welcome to Drafting Affidavits. Yeah, I did a little ad hoc here. Didn't get the 30-minute notification because I didn't do it 30 minutes before. But I'm glad you got the notification. So, that being said, let's get started. We got a good presentation tonight. Drafting Affidavits, a layperson's guide. And this one is actually from the British Columbia Supreme Court. So, for Canadian viewers out there, they might be more familiar with some of these terminology and vernacular used throughout this document. However, the principles of drafting affidavits still applies universally. And this was revised in April of 2005, so rather old document. Nonetheless, let's read me first. So this is parts 3 to 4. Let's see here. Where's parts 1 and 2? Okay. Well, parts 3 to 4 of this guy will help you prepare an affidavit for the British Columbia Supreme Court. We won't be doing that, so we won't be too focused on 3 and 4, but it does have for that. We will note the proper form, the structure of an affidavit, and tips for drafting an affidavit. Please read the warning and waiver of responsibility on the next page, and better yet, let's listen to mine here, because everything you hear and see tonight is strictly for the entertainment educational purposes of this YouTube broadcast, not to be used misconstrued for anything personal, private, legal, lawful, financial, tax, or otherwise. So please don't do this at home. All right, now that we've made our waiver and responsibility disclaimer, let's continue. Here's theirs. Can't be liable for theirs, and what's new in the 3rd edition. So we get to our table of contents here. Preliminary. Also the clickable links here. So let's continue here and just read through. We get the introduction, the preliminary, and the express lane. Then we go over general information about affidavits. Then we go to the purpose of the affidavits, which include the relevancy and the facts. As again we say about relevancy, it may not necessarily apply to the central issue of the case, but it would apply to other issues that might then be part of a material issue. Again, the central issue isn't essential. So, structure of an affidavit: the introduction, the style of proceedings, the deponent's statement, the knowledge statement, body of the affidavit, and the ending of the affidavit. Then you could have exhibits and a backing sheet. And then we have some sample affidavits. And then we'll go to part 4, tips for drafting affidavits, the SOS principle. Simple, organized, and short. SOS. I guess that's the Canadian version of the KISS. Then we have format of the affidavit. Read over, take your time, vagueness, credible affidavit, what to put in your affidavit. Then we have some sample paragraphs. Then we have here 5 questions for the lawyer. Whether that is relevant or not is up to you. Part 6, a checklist for the affidavit. Part 7, you're not going to find that here. There's no legal advice here. This is strictly for the entertainment educational purposes of this broadcast. Then we have Form 60, whatever that is, sample affidavit. Then we have 2 appendices. All right, let's get on here. Check over here to the chat if there's anything else in here. Greetings, we have Audit Them in here. Greg, great to see you. I hope you saw the, I think you did see the post on the 7 points that we discussed on the last live stream. And please hit the like if you just entered. I think it's pretty thin tonight. Notifications were a little bit late. I apologize. Nevertheless, let's proceed. So our introduction here starts with the preliminary. An affidavit is a written statement that contains important facts you wish to draw to the attention of the court. It is signed under an oath before a registry clerk or a lawyer. The affidavit is filed with the court registry. Copies of the affidavit also have been given to the other persons named in the lawsuit. Sometimes a judge sits in court, at other times a master sits in court. Throughout this guide, there is a reference to a judge, you should consider those references apply equally when a master sits in court instead of a judge. I love the throughout is two words in Canadian, I guess, and they have masters as well as judges. I guess it's like a magistrate or something. I'm not sure. Nevertheless, I don't want to digress. Express lane. So we have a shortcut here. If you want a quick service and advice on preparing affidavits, you should follow the following procedure. This procedure will enable you to short circuit some of the material in this guide. However, it is recommended that you read the whole guide and go over it with your best friend. See, step 1. Take sample A to your best friend giving you legal. Oh, geez. We're not going to short circuit our thing. Let's just continue here because we don't want to solicit legal information. Part 2, general information about affidavits. Purpose of affidavits. We use affidavits to present evidence to the court. Wow. Sometimes courts hear evidence from witnesses who give their evidence orally in person. A good example of this is the TV show Law and Order. However, for certain court cases, you must present your evidence by affidavits. A lawyer can tell you if your case requires an affidavit. Your best friend can also tell you. The person who signs the affidavit states that the information contained in it is true. And remember, this is our subjective truth, that if enough people consider it true, it becomes or is regarded as an objective fact before the court. The affidavit may have attached letters or other important documents. These are often referred to as exhibits to the affidavit. There are 2 important things to remember about affidavits. 1. Relevancy. Statements made in the affidavit and documents attached to the affidavit must be relevant to the matter before the court. This is the key to having a good affidavit. It is important for you to get good advice on the legal issues relevant to your case. What are the important facts that have to be put in the affidavit? People can answer that question. The preparation of the affidavit must also be done in the context of the whole case. So we're looking at the completeness, right? What are your strategies for the court case? Your affidavit should be drafted in that context. Again, this is a reason you should pay attention. 2, facts. Affidavits contain facts, not opinions. For instance, the following is a fact. 1. I saw Tom Smith hit Harry Jones on the nose on February 7th, 2005 at 3 o'clock p.m. This occurred outside the home of Harry Jones at 123 Main Street, Vancouver, British Columbia. Following is an opinion. 2. I think Tom Smith is a bad person. Our first example is a classic example of a fact. You saw something happen, and you have personal knowledge as to what happened. The second example is pure opinion. Maybe you could show that Tom Smith hit 5 persons. The court could infer that Tom Smith is a bad person. However, what you have to do in an affidavit is set out facts and not your personal opinion. Sometimes opinions are important. For instance, doctors and other experts give up their opinion. However, for most of the time, a layperson will be presenting facts and not opinions in the affidavit. All right, we're on to section 3. Jump over here to the chat and see if we're up to date here. We're losing people faster than we're getting them. Is anyone still there? Part 3, structure of an affidavit. Introduction. There are 7 parts of an affidavit. Are these the same 7 points? No, these are different. We had 7 points that were discussed about a commercial instrument, But there are 7 parts to an affidavit, and these seem a bit different. So let's look at these 7 points. The 7 parts, not points, 7 parts. There we go. The style of proceedings. 2. Deponent's statement. The deponent's statement, person making the affidavit. That's the deponent. Knowledge statement, body of the affidavit, ending of an affidavit. Then 6 is exhibits, and 7, the backing sheet. Of these 7 parts, the most important part is the body of the affidavit. The body of the affidavit is discussed in detail in Part 4. This, Part 3, will concentrate on the more technical aspects of the affidavit. The rules of court specify that a certain form must be used in preparing an affidavit. The rules of court in British Columbia use Form 60. It is reproduced at the end of this guide in Part 7. It is also available at their website. Style of proceedings. A style of proceeding is a greeting that appears on the first page of all court documents. It states who is suing whom and also gives a file number and court registry name. The style of proceeding remains unchanged throughout the life of the court case unless the judge otherwise orders. The style of proceeding enables the court registry staff to put the document in the right court file. There's an additional requirement that has to be put on if the court document is an affidavit. There must be written in the top right-hand corner of the style of the proceeding the initials of the deponent, the sequential number, the date. Example follows. Okay, so this is technical stuff here for British Columbia. And we're on to the knowledge statement here. We had the, what is this here called? Deponent statement is the following. I, electrician, 123 Main Street, City of Vancouver, Province of British Columbia, make oath and say that. Oh, that's a good one there. Make oath and say that. That's rather brief and to the point, and without all that nonsense. The deponent statement has to be put at the beginning of each affidavit. The person making the affidavit and where they live and what is his or her occupation. Oh, wow. If you're an old age pensioner and you would put on it retired or old age pensioner. Wow. That's kind of odd, but I guess that's just for theirs. Knowledge statement. The knowledge statement has 2 aspects. First, you should state in it whether you are the plaintiff, defendant, petitioner, or respondent. Secondly, affidavits must contain information and facts within the personal knowledge of the person making the affidavit. Affidavits should not contain information told by other persons unless the other person is a party to the court case. Therefore, you would put the following statement. I am the plaintiff in this matter and have personal knowledge of the matters herein referred to. This prohibition against information and belief does not apply if the matter before the court is an interlocutory order. The lawyer can, usually, this is the lees, be careful, those are presumptions, it doesn't always apply if it says usually. The following paragraph is put in if you are able to have an affidavit on information and belief. I have personal knowledge of the facts and matters herein referred to by me, except where indicated to be on the information and belief, and where so I state I verily believe them to be true. You will also have to indicate in the affidavit the specific person you are relying on for the information and belief, and a statement to the effect that you believe it to be true. For example, you would probably have to say something to the effect of, on or about August 30th, 2004, John Smith, her husband, told me that Mary Smith had not gone to work that day before, and I believe this to be true. That sounds kind of fishy. You'll have to obtain, okay. So we get to the next step here, the body of the affidavit and the ending of the affidavit. The body, we'll get into that in the next part. The ending is when we're sworn in front of a lawyer or commissioner for taking affidavits. In this country, I think we call them a notary public. Wow, 31 bucks, huh? Canadian dollars at that. All right, we have exhibits here. The exhibits, if any, are arranged in alphabetical order, A, B, C, etc. Each page of the exhibit has to be numbered consecutively. Each page of the exhibits. Therefore, if you have exhibits A to G, totaling 40, one exhibit may contain 2 pages and the other 8 pages. You start numbering with page 1, you finish at page 40. You print in the number for each page of the exhibits. Oh, okay. It's best to put each number in the middle of the page. Exhibit stamps go on the first page of each document and they read as follows. This exhibit, referred to in the affidavits form before me. Okay, cool. Then we have a backing sheet, part of an affidavit. This document is attached to the back of all court documents with the type facing out. Oh gosh, okay. So let's get to part 4, because this is really the parts where it's going to apply universally. We saw now some important distinctions in British Columbia court that don't apply here in the United States of America. So let's see here. Tips for drafting affidavits, which is the main topic here tonight. The SOS principle. One of the keys to success is to follow the SOS principle. That's simple, organized, and short. I like that. Simple. Try to make your affidavits as simple as possible. Use simple words and sentences. Many people think that if they make things complicated and sophisticated, they will impress the judge. The judge will see through it. Judges are more impressed with a simple affidavit. Also, a simple affidavit is easier for you to prepare and to present to the court. Now we're on to O, organized. The second principle is that your affidavit should be organized. This is the most important rule. If your affidavit is organized, it is easier for the judge to understand what is going on. In most cases, if you're telling a story, it is best to tell what happened in chronological order, date-wise. Do not jump all over the place from one time period to another. Tell your story in a straight line. Try as much as possible to give specific dates. When referring to people, it is best to use their names. Try to avoid using him or her. We heard this before, to avoid pronouns. It can become confusing to whom you are referring. You can organize your affidavit in a different manner depending on the nature of the case. For instance, in custody disputes, presentations are usually organized on the basis of considerations stated in the Family Relations Act, Divorce Act, and the court considers in granting custody orders. Get legal advice on the best way to organize your affidavit. And our last one is short. The third principle is to keep your affidavit short. It is more effective. First, determine what is necessary to put in your affidavit. Put that in the affidavit. Don't fall into the trap that more means better. Same rule is true of paragraphs and sentences. Keep them short. Sentences should be less than 10 words. If you can make sentences shorter, then do it. A good strategy when editing your affidavits is to break long sentences into short sentences. This does not mean you ignore important matters. However, if your affidavit is short, it allows both you and the judge to focus on the important matters. Format of the affidavit. The body of the affidavit should contain statements of relevant facts. The affidavit should be drafted generally in the first person. For instance, a sentence would read as follows. I went to the appeal hearing on March 23rd, 2003. Here are some additional useful tips. Ready? 1. The affidavit should be done on white paper, 8.5 inch by 11 inches. The font size and spacing should be the same as a sample affidavit of Mary Smith in this guide. Why don't they just tell us? 3. Consider putting headings in the affidavit to make it easier to organize. See sample affidavit. 4. Each page should be numbered. 5. Each paragraph should be numbered. Read over. Have your friend. Oh, good. See, I told you they're relying on the friend here. Check your affidavit to make sure there are no typing errors and the language is clear. In addition, it is highly recommended that your affidavit be typed and not hand printed. Although in theory you can provide a hand printed affidavit, this should be avoided. Take your time. You should attempt to draft the affidavit over several days in order that you have enough time to contemplate what needs to be done. This may not be possible as you may be in a hurry. Vagueness. Affidavits should avoid vague statements. The following is an example of a vague statement. I met the defendant contractor John Smith on several occasions. I walked away from these meetings with the impression that he would not charge me for the extra paint put on the porch. This is a vague statement. A better statement to put into the affidavit would be as follows. I had a meeting with the defendant contractor John Smith on April 3rd, 2004 at my home in the late afternoon. He specifically stated to me, quote, I will not charge you for the extra paint on the porch. I relied on this statement that he would not charge me for this extra paint. So there we go. We get a vague statement and then we have a not vague statement. Notice how the not vague statement is a little bit longer. So again, this SOS thing here we're looking at, short is the third one on here. Most important is organized. And simple means that you still need to keep all the important ones that you need. Or that was short. Determine what's necessary. All right, we're on to credible affidavit. Before we do that, let's jump over here to the chat. Dem is still here. And welcome to Roger Tomlinson. Howdy to you. So, credible affidavit. Persons representing themselves often ask, how can I make a credible affidavit? First rule is that you should tell the truth in your affidavit. Judges assess credibility based on the following factors. 1. Are there internal inconsistencies in the affidavit? For instance, does the person making the affidavit state one thing in one part of the affidavit and in another part of the affidavit state the opposite? 2. Are statements made in the affidavit inconsistent with other statements made in other affidavits or documents outside the affidavit? Sometimes in a rush you may carelessly make mistakes in an affidavit that are at odds with other affidavits. This could hurt your case. Yeah. Is the statement inherently unbelievable? If a person is late for work and his excuse is his car ran out of gas, that's believable. However, if his excuse is he was beamed up from the Starship Enterprise to have dinner with Captain Kirk, that's probably unbelievable. 4. Is the person biased in making the affidavit? Do the statements in the affidavit show an obvious bias? There are also additional factors to be considered in determining the credibility in affidavits. So let's look at some of these. 1. Is there a statement of conclusion with no details to back up the statement? Remember, judges like to see facts, not broad general statements. 2. Are there statements in the affidavit that are evasive? This is done by skillful drafting. In other words, does a person making the affidavit attempt to avoid an issue or statement? An example would be one affidavit says you and another person had a conversation on a certain day. You state in your affidavit that you never personally met that person on that day. That is true, except that you did have a telephone conversation with that person. This is an example of an artful drafting. You should avoid this. Does a person use language that one would not expect a normal person to use? Judges prefer people to use their ordinary language. Is the second best evidence used instead of the first source? Remember we looked at the best evidence rule and the rules of evidence, law of evidence. Even if you are allowed to make an affidavit on information and belief, it may be in your interest to get the person who had the original information swear an affidavit. This is more effective than relying on hearsay. Please note that not all court proceedings allow hearsay, information, and belief. And there are the hearsay exception rule. Is there a lack of precision or preciseness in the affidavit? Does the person making the affidavit not use precise dates or precise information? 6. Are there mistakes that indicate the person making the affidavit has not read it? This would include typing or grammatical errors. 7. Are important facts left out? If important facts are left out, this may indicate the person making the affidavit is hiding something. What to put in your affidavit? There are 2 types of information that you should put in your affidavit. Most court cases require some basic information to be put in your affidavit. Certainly, you have to put this type of information in. In addition, each court case, there's a special information that should be put in that affidavit. Again, sample paragraphs. Here are some sample paragraphs. And we go on to information on belief. On or about August 30th. Okay, so we get some good little samples there. Here are some questions for your friend. Was the style of the proceeding in this matter? What are the important facts I should put? How should I organize it? In chronological order. From whom should I get an affidavit? Can this be based on information belief? Should the documents be attached to the affidavit as exhibits? If so, which documents should be attached? When does the affidavit have to be filed? To whom do I have to give copies of the affidavit? And what is the time limit for doing this? Has the commissioner printed as well as signed his or her name? Maybe a little checklist here. Have you picked the right person affidavit? This is okay checklist here. Have you entered the name, address, occupation? Sentence short. Broken one long sentence into 2 short. Have you used simple language? So it's not that great of a checklist. Arrange the story in chronological order. Attach exhibits. File registry. Jeez here. All right, well, let's read some of this stuff here anyways. Introduction, whistleblowers, various free, whatever. Bring a friend for moral support. Depending on the nature of the problem, the friend can sit through the interview with you. Oh, geez, really? Okay, so now we're listening to some stuff here. Oh, I see what it is. Salvation Army's pro bono. Didn't know about that one there. Guess that's worldwide. So let's look at some of these here, the affidavits here. Style of proceeding. Affidavit, I make oath or solemnly affirm and say that. This is nice. Okay. Here's another one, Supreme Court, British Columbia. I, the welfare recipient, make oath and say that. Nice. Affidavit of Mary Smith, Appendix A, Appendix B. Oh. All right, Appendix B. What is the style? Okay, so this is the sample they're saying you can use as a template right here in British Columbia, I guess, for their Supreme Court. Or you can download the one off their website because it's online. All right, what is the style of proceeding in this matter? What are the important facts I should put in the affidavit? Should I organize my affidavit in chronological order? This is our checklist here. I already went over this. Okay, excellent. So that takes the end of the text. And a nice little template here. We'll zoom out on that so you can take a better look at the whole template in one shot. This is for our Canadian friends. And that's it. That takes us to the end of the presentation. I'd like to thank everyone for coming out here and spending some time to learn about drafting affidavits. Even though we are getting this from a Canadian perspective, the principles still apply for some of these, especially at Section 4, where we get into the details. I think a good takeaway from this is the SOS style of keeping things. I think in the order there was short, was it simple, organized, and short? Simple, organized, and short in that order. And I think that's a good takeaway that we could all apply for not just affidavits, but many other types of writings and communications. So with that being said, I'd like to thank you all for coming out, and I hope to see you all on the next one. Peace out.